is not about the judiciary. It is about a clique of judicial officers who have gotten into an unholy relationship with a clique of activist lawyers and oppositionist civil society people, with the intention of humiliating the government, stalling the government, embarrassing the government, and making it impossible for the government to perform.
An unholy relationship. Gentlemen, you were listening to that. I'd like you to weigh in on this issue. And today we're seeking understanding. So this was in response to whether they ignored court orders, should have obeyed them. Ndegwa, I'd like to go to you.
Yes.
If there is a court order that has been issued
yes.
in a case that I'm involved in, and
Correct.
I'm required to go to court tomorrow at 9 a.m.
Yes.
If I don't like it, do I have a choice? Do I not like it? What is the procedure here? Because at the start, Steve said this is an issue also of procedure that should have been followed. So does any individual have the right to say, well, I'm not sure, but you see also Miguna did not quite, obey the law?
Yvonne, we gave unto ourselves a new constitution. And there are some promises that we made to ourselves as being Kenyans. And among those creeds is a creed that power belongs to the people and it shall be exercised in the name of the people. And then the people of Kenya went ahead under Article 1 to designate and donate these powers to various institutions, among them the judiciary, the executive, and the legislature. Then, while enacting the same creed, we told these three arms of government, remember, this is not your power. It is our power. We have donated this power to you. You must act in correlation and in respect with mutual respect with each other. And these three arms of government must also check on each other while they respect each other. The Kenyans people never stopped at Article 1. They went further to Article 159, and they said that, which Article 159, which establishes the judiciary. They said that judicial power is derived from the people and shall be exercised in the name of the people. So we have two articles establishing the sovereignty of the people and further establishing an institution that is supposed to exercise the sovereignty of the people, and that institution is the court. So when a court issues an order, it is not Justice Odunga who issues that order. It is not Justice Chacha Mwita who issues that order. It is not Justice Maraga who issues that order. It is the people of Kenya who have issued that order. Because that particular judge is exercising the people's powers. So it is wrongful for someone, therefore, to disobey a court order and purport to think that he or she is possessed with sufficient information and knowledge and wisdom to attempt to interpret that order as what it says, or to lay blames on that other person. For instance, when an order is issued by the court, there is no one who can say that, yes, even Miguna has disobeyed this order. First of all, obey the order, even if that order is as idiotic as it may be, even if it is as reasonable as you perceive it, obey that order and then follow the rightful channel that are supposed to be followed.
Okay.
It pains me, Yvonne, when I get to listen to C.S. Matiang'i trying to isolate some judges of the judiciary, saying, no, it's not the whole of the judiciary. There are some judges who are trying to interfere with the holy relationship between the executive and the judiciary. That is a very bad way of looking at things. One, it is not a constitutional way of looking at things. Two, it tells me that Matiang'i does not appreciate the provisions of Article 10, which says, or which lays down the principles and the values of governance. And among them is the value of the rule of law, the value of democracy, the value of inclusiveness. When you talk about inclusiveness, we are not just talking about inclusiveness, including Wajiko in budget allocation, in resource allocation. It also includes institutional inclusiveness. And that is why I do not agree with C.S. Matiang'i when he tries to isolate one judge and start bashing him.
Okay.
It is a very, very unhealthy way of institutional relationship of institutions in this country.
All right.
Yes.
You, Steve, are talking about the issue of procedure being also another important aspect in this case.
Yeah, first of all, Matiang'i himself should stop wearing power like cheap perfume. He should remember that his term will surely come to an end from government, and he will need the protection of the judiciary that is now ridiculing and also embarrassing. And the same goes to the lawyers that he's attacking. Now, this question, if you look at the issue around compliance of court orders, Yvonne, it is as simple as saying that you live under Constitution, the Constitution is binding, the people that have the authority to interpret the Constitution definitively is the judiciary. These are matters that are in the public domain. The way to vacate a judicial determination is by appeal. It is
which he says he has done.
Which he has done after he failed to appear in court. And you know, it's a very indecent and inglorious attempt to try and isolate the judiciary by appearing before the Parliamentary Committee on Security, you know, thereby lending credence that the political wing of government, the executive and the legislature, and then attempting to isolate the judiciary. Yet, what Matiang'i must know, and all Kenyans surely do know this, that in terms of the interpretation of the Constitution of all applicable laws, the voice of the judiciary is final. You can't explain away a judgment. You can't do it in a press conference, in a parliamentary meeting, in a newspaper column. You just can't. The way to vacate that order is to move up in appeal. Explain yourself. That's what lawyers do. But we've seen a very disturbing trend of disobedience of court orders.
Well, what happens in the event where today the CS and the PS said they've not received any court orders, have not been served?
What we have seen, and the Constitution has rejected that approach. This is a manipulative approach to interpretation of the law. That since the law says, I must be served and you haven't been served, who doesn't know that there was a court order issued? I mean, you see, Yvonne, the thing is this. Law is not removed from common sense. I mean, the law and common sense are inextricably linked. This issue of Miguna and other similar issues are being litigated, and they're being covered live. A judgment is being given, a ruling is being delivered, it's being delivered live. You can't tell me the entire government machinery or functionaries don't know there's a judgment, and they can't even request, okay, come and serve us. This is an approach that can only be described as manipulative.
Okay, manipulative, you say, but yes. The Cabinet Secretary Matiang'i said today that unholy relationship, rather a strong phrase, but you know that there are judicial officers who are seeking to embarrass and humiliate state officers and members of the executive. So, you know, where do we go from here? I mean, you know.
Well,
what does this do for the relationship between these arms of government?
I think I want to just speak to Kenyans. I want to ignore what Matiang'i said. He's not a lawyer. He can't understand how laws are interpreted and applied, unless he's saying that that is the advice he received from the Attorney General, in which case the LSK must do something about the AG's ability to advise government. Because, you see, to attempt to isolate a particular judicial office, and there's been this ethnic profiling of judges, politicization of judicial decisions, for expediency. You know, when you select, and we said this, Yvonne, during the electioneering period, that both NASA and Jubilee have cultivated a culture of impunity, you know, around governance, that you can select when you want to be bound by the law, and you can select when you want. Basically, our politicians are telling us that they are immune to legal processes. One time it is NASA disregarding the law, the other time it's Jubilee disregarding the law, and Kenyans are required to act in compliance. But I want to tell Kenyans this. The judiciary that we have now is truly an ascendant judiciary. It has constitutional control measures to protect it against external manipulation. So no amount of intimidation or threat to judicial officers will demoralize them. And I want to tell Matiang'i that if they continue to attack the judiciary, some of these judges will begin to resign out of clarity of mind. Because you can't interfere with the integrity of judicial thought, you know, and voice, because you want to shape the opinion to a particular format.
Okay, all right.
Yes.
Ndegwa, I want to give you the opportunity to give your final thoughts now.
Yes, I have an opinion in respect to the way the government is relating with the courts. Since 2013, Jubilee has been having a lot of stomach aches when it comes to the courts. They have not cultivated a very healthy relationship between the executive and the judiciary. The clamor of it all was after the 8th August judgment that was delivered by the Supreme Court. Remember, the president is on record saying that he ni koti ya wakora. So when the president who is highly held in high esteem by the Kenyans, makes such kind of a statement directed towards the judiciary, what that goes to do, it goes to mutilate and erode the confidence that the Kenyans had with that particular institution. The question is, the question that Kenyans ask themselves is, if the president is not comfortable with the judiciary, then who am I? So we must do a very serious and concerted effort to try and build confidence with the judiciary. Remember, we cannot establish our court outside the confinement and the definitives of the Constitution. We have to act and live within the realms of the Constitution as enacted. So my plea to A is, we must stop this bashing of judges. I do not know why Justice Odunga is of so much particular interest to some clique of individuals, either in Jubilee or in NASA. When Justice Odunga sits to execute his judicial task, he never sits as a Jubilee sympathizer or as a NASA sympathizer. He sits as a judge of the High Court of Kenya. And we must be able to dissuade ourselves and divorce ourselves from that tribal aspect of looking at how is the name of this judge spelled. We should not define the judge by the name or by the way his name is spelled. Justice Odunga is a judge of the High Court of Kenya. And Makiu, and these Kenyans must know, Justice Odunga is one of the judges who has contributed to the growth of one of the best and rich jurisprudences in this country. In matter of fact, we lawyers refer to Justice Odunga as the Atkin or Judge Lord Denning of Kenya. So the president has a duty of trying to make sure that he has built confidence, he has made Kenyans to build confidence with the institution. He has also a responsibility of making sure that our institutions work and we have confidence with the institutions that have been created by the court. So finally, the LSK also has a responsibility of making sure that Kenyans also understands the mandate of a court, the mandate of the judge. How many divisions of the High Court do we have? For one reason, Yvonne, Kenyans keep on asking themselves, why are particular cases always held or heard by Justice Odunga? The reason is one, that the judiciary has, or the High Court has many divisions. It has the commercial division, it has a judge who heads it, it has the family division, has a presiding judge, it has the family division with a presiding judge, has the constitutional division with a presiding judge, and it also has the judicial review. And the judicial review is headed by Justice Odunga. So it is at the presiding judge bench where the buck rests. So Kenyans need to worry not why most of these cases are heard by Justice Odunga. It is because he is the presiding judge of that particular division, which is called the division of the judicial review.
Ndekwanjiru, yes. Thank you very much. And to you as well, Steve Ogolla, for helping us get some understanding on this issue. Thanks very much to you watching us as well. I think I have time to read just one or two. Alan Makodhiambo says, so the state knew Miguna had a dual citizenship, yet was cleared to vie for a gubernatorial position. State is expressing how carelessly they handle citizenship issues. Soon, most Kenyans will be rendered citizenless. There's more of that. Ike Ojuok says, is it not the police under Matiang'i's orders that first violently arrested Miguna from his Runda home, refused to present him in court, and forcefully deported him? Why are they now crying foul that the judiciary is bullying them? Kiama Kihonge disagrees with Steve Ogolla, says he's misinformed. Sections of international airports and embassies are not considered under state jurisdiction. You cannot even be arrested if you took refuge in those places. Danson Nkuruna says it's best that Miguna reapplies to be a Kenyan citizen after the 2010 constitution paved way for dual citizenship. Okay, so there's much more of your feedback. Please go to the hashtag #TheBigStory. I want to read one more comment here, and this is from Advocate Gitobo Imanyara, who is watching the show tonight. He says, the most apt answer to your question, can you lose your citizenship of birth, is to ask yourself whether you would cease to be a human being by declaring you are not a human being. Citizenship by birth inheres in you by virtue of having been born in Kenya. You can never lose it. International law does not recognize statelessness. He cannot lose the Canadian citizenship. He can lose the Canadian citizenship, but not the Kenyan one. Thanks to you as well, and for your feedback, a conversation that will continue. We'll continue to cover this story in the ways in which it will continue to develop. That is the big story tonight. I'm Yvonne Okwara Matole.